I'm Joe Romano, a member of the Burns-White Workers' Compensation Department. I've been practicing workers' compensation law for about 10 years. I solely represent employers and insurance carriers in workers' compensation claims. The next topic to discuss is not necessarily individuals who sustained a COVID-19 exposure at work, but individuals whose job may have been impacted by the COVID-19 quarantine or may have been impacted by the economy after COVID-19. The primary focus in all of these scenarios is going to be whether that individual is working a modified duty job or they are working their original pre-injury full duty job. A secondary consideration after that will be, did the employer voluntarily shut down? Was there a loss of wages due to an economic reason? Or were they mandated by the government to shut down? To start, if an individual is working modified duty and they were voluntarily laid off or the economy has caused them to be laid off, they are going to be entitled to a presumption of disability, and the far most likely scenario is that their benefits should be reinstated upon the loss of earnings. However, there is more room to argue if the injured worker was on modified duty and the government mandated the employer to shut down rather than a voluntary shutdown. In that circumstance, there may be an argument that the employer's shutdown was caused by the government, and that scenario has never been addressed in any case law that I am aware of. I am not aware of any situation where an entire company was forced to shut down due to a pandemic. While the initial analysis will be that the injured worker enjoys a presumption based upon their modified duty status, there will be some challenges in the law that is based on the fact that the employer would have remained open but for the mandated government shutdown. And there's a question that will eventually arise as to whether that justifies an ongoing suspension of benefits, whether the employee enjoys the presumption of disability and will then be reinstated into TTD benefits. My anticipation is that the injured worker will be entitled to those TTD benefits. Lastly, if an individual is working their full duty job, they will not be entitled to a reinstatement regardless of whether there is a voluntary shutdown, an economic layoff, or whether they were mandated by the government to shut down. The full duty status supports an ongoing suspension. If an individual has been reinstated or if an individual will be reinstated, it is necessary to determine other income that individual may have during this pandemic. Specifically, it's going to be necessary to confirm their receipt of unemployment compensation benefits. And this will not only include the state unemployment compensation benefits, but also the federal unemployment compensation supplement that has been provided. In most instances, the combination of a state unemployment compensation benefit as well as the federal supplement will entitle a dollar-for-dollar offset that would essentially wipe out any reinstatement that an injured worker would be entitled to. So it's necessary to right away confirm whether they are receiving unemployment compensation benefits or whether they're intending to apply for unemployment compensation benefits. With respect to the federal supplement, the claimant's bar is advancing an argument at this point that we are not entitled to a dollar-for-dollar offset based upon case law that may be analogous but is not on point on this necessary issue. And there will eventually need to be a decision rendered on this narrow issue of whether we are entitled for a dollar-for-dollar offset of that federal supplement.